Progress. Hey, guys. I'm so excited that you guys came on. This is our third episode, our third Talk 30 to me. And so if you haven't been on here before, Talk 30 is really just an opportunity. It's a question answer session, an opportunity for people to just have conversations that they don't normally have, but that are very important. So again, conversations that we don't necessarily think of sexy, but it is sexy to have generational wealth. It is sexy to take care of our families. It is sexy to be able to have a plan in place, after we're gone, so our loved ones know what's going on. And so tonight, I am very excited to have Crystal Juga here. She is an expert in, in estate planning. She's an attorney, and this is what she does day in, day out. And because of her own experiences that she's had in her own life, it just gives her this extra special passion to do this work. And she literally does know very much about this topic. And again, it is super, super important. So we're going to start with Crystal. We're going to do it a little bit different today. We normally start right off the bat asking questions, but we're going to let her speak a little bit and then we're going to do question answer for the rest. Everybody okay with that?
Yep.
All
Yes,
right.
yes, yes. All right.
Yep, yep.
Go
All
right
right.
ahead, Crystal.
Well, thanks, Cindy Lee, for inviting me. I'm super excited. I do a lot of presentations, but it's usually just me talking a lot, so I'm really excited to kind of do this Q&A style. Again, my name's Crystal Juga. I'm the managing attorney of Juga Law. We're an estate planning firm. We do elder law also here in New York. And again, as Cindy Lee said, this is a very near and dear area of the law to my heart because my family has made all of the estate planning mistakes probably a family can make along the way. And, we weren't a wealthy family. So if you think that you have to be wealthy to need estate planning, I've lived through that reality. Um, and I mean, like hear the word estate for estate planning, it's just the word estate sounds like it's something fancy, right? But the reality is, if you own anything that somebody would have to figure out what to do with if something happens to you, then that's an estate. If you have someone who's going to have to help you manage your affairs, if you're sick or incapacitated and can't do it yourself, then you need an estate plan. If you have minor children who you want to make sure are raised by the people you want, the way that you want, if the unexpected happens, then you absolutely need to have an estate plan. In fact, it's probably more important for us parents with little ones. I have a 6-year-old and a 2-year-old than it is for anyone. Um, and so, that doesn't mean you need to go out and spend thousands of dollars on this fancy estate plan with multiple trusts and this and that, but you need to have a plan for not leaving your loved ones in a real mess if something happens. And the reality of the situation is, well, my own story with estate planning started when I was 16. I had no idea that it even touched on estate planning. I was 16, my mom was just 41, and she tragically was ended up on life support because of a gunshot wound that left her paralyzed, and she had some complications from that. And unfortunately, my parents were divorced at the time, and her family, they were fighting over whether or not to take her off life support. So they're like, "You're her only child. You're 16, you're her only child. Whatever you want to do is what we'll do." And so, I'm sure they thought they were doing the right thing by me. But the reality is, I don't think anybody would want to put that burden on their young person. And, before that, she was young, she was healthy. We didn't think we were like I said, we were not wealthy. So we had never talked about estate planning. She was healthy. We had never talked about what would you want in these end of life decisions. So, we made the decision to remove life support and she did pass. But even today, I still wonder, like, did I do the right thing? Is that actually what she would have wanted? In my heart, I think that it was. Um, but again, that's just to show you one way that just that's an estate plan is talking
Mhm.
about your medical wishes, putting what you want in writing. And the reality of the situation is if something does happen to you, whether that's you're incapacitated or you pass away and you don't have a plan, you better believe the state has a plan for you.
Mm.
And that might not be the plan that you'd want for your family. So if you own anything and you die without a will, guess what? State law decides who's getting your stuff. And you might be surprised to know it's not all going to your spouse if you have kids, or it's not all going to your kids if you have spouse, even if it's a second marriage. Um, if you're incapacitated and you don't have somebody with the legal authority to sign for you, and that's, guess what? That's not your spouse. Then you have to go through guardianship procedures. And so, again, lots of families, you know, think that they don't need this fancy plan in place, but most families, they don't want to end up in probate court. So if you die without a plan, or even if you die with a will, and we can talk more about that, I think we have a lot of questions about that, then the default is your family ends up in court. And, a lot of families, if they knew that that was an option, they might opt to avoid probate. And why is that? Well, it can be expensive. I usually estimate 3 to 5% of whatever the assets going through the process are. It usually takes 9 to 12 months in New York. And you may not know it, but it's public. So if when you die and you're going to probate court, um, anybody can go to websurrogates.gov. I don't know the exact web address, but you can go on now if you're a nosy neighbor or friend, you want to see the dirty laundry of, your neighbors or whatever, and see who's getting what they owned when they passed away, because there's an asset inventory, who's causing problems, who was cut out of the will. So that's just kind of the reality of it is you may not think you need an estate plan, um, but everybody needs a plan.
Everybody needs a plan. And because
Yeah.
you love your loved ones, you
Yeah.
want to make sure that you have a plan for them because like I put on the flyer, hope is not a plan, right?
No.
And
Yeah.
hope doesn't hold up in court.
Yep.
And
And that's
probate can take years. I have a client I
years.
spoke to yesterday. He said it took 5 years for his grandmother's.
Yeah.
That's a long time.
Yeah, the 9 to 12 months is really if everything's going smoothly,
Yeah.
and everybody's getting along, and that's the other pieces. And I want to get to the questions, but if you have minors, if you have children, young kids, and you don't have a plan and you haven't named guardians, then guess what? A judge is going to have to make a quick decision. Anybody can come forward to be the guardian of your kids, and the judge doesn't know what you would want. So they have to make a quick decision based on the information that's available to them. And that's the person who's going to be raising your children, even if it's somebody you would never have wanted. And I know that, again, my brother passed in his 40s with 5 young kids. And my sister ended up in a battle with my ex-sister-in-law's family for guardianship over a year. You know, she ended up with guardianship in the end, which I think was the right decision. But who knows if my brother had just put some guardianship documents in place, they could have avoided all that conflict. And now they're not even speaking to each other. So
Wow.
yeah, all right. Um,
You
I
want
don't
to
know
get
if
started with the questions?
yeah, let's go ahead.
All right. I've got them, but I see that there was one in the chat
Oh,
already that said, even if you have beneficiary assigned, I don't know at what point was that asked. It
yes.
was,
So that's a great question. And I think that, that's the great thing. Beneficiary designations, if you have life insurance, if you have retirement accounts, those are common assets that people designate beneficiaries, which, if you know anything about it, that's kind of the good thing about it is it avoids probate, right? And it answers one question. A beneficiary designation answers one question. That's who gets that asset. Well, my question to you is yes, it should avoid probate. Well, did you name a minor as beneficiary? Because if you did, then you might not know, then that's got to go to probate so the judge can decide who's going to be managing the assets for that minor. Um, what happens if the person you named as beneficiary passes before you? This is a true story. I said my brother passed away young. His mother, we are half siblings, so different moms. His mother
Mhm.
lived 10 years after he passed. Years prior, she had named him and his wife as beneficiary. For lack of a better term, deadbeat wife who left her children for my sister to raise was named as beneficiary. Well, his mom forgot that she had even named beneficiary. She forgot about that insurance policy. So when she passed away, my brother died before her. My sister-in-law was incarcerated at the time, was the other beneficiary. She ended up with the money. She didn't spend one dime of it to take care of her kids. I know that my brother's mother is probably rolling over in her grave at that. It's just I think we rely too much on beneficiary designations to do our planning for us. And it can be a good way to avoid probate, but just when you're doing your beneficiary designations, keep in mind you need to babysit them. Any change in your life that happens, you need to stay on top of it. You need to know what happens if, you know, again, somebody, your beneficiary dies before you. What if they're disabled and they need Medicaid? Well, now you're just disqualifying them from Medicaid because they're getting an inheritance and now they have too much money. So you just need to be aware of the consequences.
Any follow-up on that, Cleo? Does that answer your question?
Thanks.
Okay.
Yeah.
So I will jump to some of the questions that you guys submitted when you registered. So, somebody had said here, what are the benefits of a trust versus a will?
Great question. And I think if you don't take anything away from tonight, take away that a will does not avoid probate. I have people come into my office probably once a month thinking with a loved one who unfortunately had passed away with a will, thinking that they just going to wrap it up in my office. And that is not the way a will works. Where there is a will, there is a probate. A will is your first class ticket into probate. It doesn't change anything about the process. It can change who you want to get your assets, and it can answer kind of those other important questions that a beneficiary doesn't designation doesn't do, like what happens if somebody passes before you, or what's happening if your beneficiary is a minor. Um, but it does not avoid the probate process. So that's the number one difference between a will and a trust is a trust avoids probate.
Okay, I'll keep along those lines. I'll just look for all the trust will questions. Um, there is a question, how do you set up a trust?
Mm. Okay, that's a good question. That is actually a very good question.
All in the chat.
Setting up a trust is very easy. You can come to my office, we'll ask you a bunch of questions, help you think through like who's getting what, who's going to help manage the assets if something happens to you, and you sign the document. And this is where I see trusts fail a lot. And sometimes trusts kind of get a bad reputation because they sign the document, you sign the document with your attorney, and then they send you on your way and you do nothing else. And then you just have an expensive pile of papers. So after you sign the trust, you have to put your stuff in it. Um, so if you have a house, we always make sure we include the deed to your property to make sure your house gets in the trust. If you have bank accounts, those either need to be retitled if the bank will retitle it, or you have to open accounts in the name of the trust and make sure your accounts get transferred there. If you have investment accounts, you should make sure that your investment accounts get retitled by your trust. So your trust needs to own your assets. And we always make sure when we have clients who set up trusts, we give them the very specific instructions. We get a very detailed asset inventory, which everybody should have. So put that on your little to-do list to make sure you have an asset inventory. But we give you very specific instructions on what you need to do with each of your assets to make sure it goes into your trust.
So you can't just set it up. You got to put
No,
stuff in
yeah.
it.
And listen, there's some work involved. So if everybody, when people ask me, does everybody need a trust? I'm like, I don't know. Are you willing to like do the work that you need to do to make sure it works? Because if you're not, then don't spend the money.
Right.
Now, do you need both?
A will
Okay.
and a trust?
Yeah.
Yes. So everyone who sets up a trust should also have a will.
Okay.
The reason being, the goal is to never use that will because we know now a will goes through probate and we want to avoid that. And that's why you probably got a trust. We still do a certain type of will called a pour over will. That way, if you forgot any assets and they end up going to probate anyways because you didn't put them in the trust, it goes through probate. But then the will says we're pouring these into our trust, and then the trust takes over managing those assets. So yes, if you have a will or a trust, you should still have a will.
Mm.
But not everybody who has a will necessarily needs a trust.
That clear before we go
Yeah,
on?
that's yeah.
Mhm.
I don't have young children. I have adult children, adult children. So it would still go through probate if I give, give them the authority you know, to take care of everything.
If it's in a will, yes, the wills go through probate.
It is, but not if I have a trust as well.
No.
It won't.
If you have a
Okay.
trust and the trust owns all of your assets, then the court never has to get notified of
Hmm.
anything.
Okay. All righty.
All right, I see a couple questions in the chat, but let me ask this one here first that says, at what age should we do a trust?
Mm, that's a great question. I would say there's no real correct answer to that. It really depends on your situation. Some people never need a trust. Um, Depends on what you own and what your goals are. Some people, I sit down with some people and they're like, I'm leaving my kids $2 million. They can wait 12 months for this to go through probate and maybe it'll be a learning experience. If your goal is not to avoid probate, then you don't need a trust. Most people don't feel that way and they want to make things easy. But again, we should try to figure out what your actual goals are. But the reality is you need to do it before you need it. So, if you're thinking about it and it's kind of something in the back of your mind nagging at you, that's probably the right time to do it.
Makes sense.
Mhm.
So how much does it cost to set up a trust? Which is going
Well,
to vary.
that is a great question, and I can tell you how much we charge for a trust. And again, it depends on what type of trust and what you're hoping to accomplish because there are lots of different types of trusts. Um, you can go to attorneys who, will just get you in to sign the documents. Maybe they'll do it pretty cheap, but they won't give you any help and guidance in making sure it actually works the way it's designed to. Um, eh, you know, eh, Again, if you want to know how much I'm fully transparent with my pricing. So, what I charge for revocable trusts. So, revocable trusts are the type of trusts that just avoid probate. They're typically the types of trusts that young families do, who are just building their wealth, and they a lot of times have young kids, and they want to make sure that their assets are immediately available for their children, and that they don't end up in probate. Those types of trust plans, we usually charge anywhere from 55 to 7,500. Again, that includes the full plan. So it includes the trust, the deed to your property. It includes the asset inventory with the full list of instructions. It includes the will. It includes all the incapacity documents, which I talked a little bit about in the beginning. So like a power of attorney, which is a document that gives somebody the legal authority to basically sign your name if you're incapacitated. It includes your healthcare directives, your guardian nominations if you have young children, your healthcare directives. That includes everything. Our irrevocable trusts, which a lot of middle class families at least do when they're thinking of Medicaid planning. So when you're thinking of, if you might need long-term care, medical care in at some point in the future, and you're trying to avoid all of your assets being taken by either the nursing home or Medicaid. Those in my office, we charge usually around 7,500 for those plans, and again, it includes the deed and all of the other documents that I talked about. But again, it's probably going to vary a lot depending on where you go.
And let me just add in here. Um, Attorneys have specialties, right? They have things that they focus on. And yes, you can probably go to any attorney and ask them to do it. But Crystal, how many times have you had people that went to an attorney that doesn't do estate planning, that prepared everything, and then the people later on had tremendous issues because it wasn't done correctly?
Yeah, I mean that happens way more than I would like to see, and unfortunately, it does get kind of give our profession a little bit of a bad
Mm.
reputation and estate planning in general, and then trusts when this planning is important. I think you know a lot of attorneys think like, oh, I can draft a will, I can draft a trust. It's a much more nuanced area of the law than most people think that it is. But yeah, I think getting some the guidance and the counsel is almost more important than the actual document itself because anybody can spit out attorney
Right.
with some drafting software can spit out the documents, but it's, the discussion and the counsel that goes into what's actually going into the document that's important.
Makes sense. I have one in the chat that says, when you set up a trust, can I list my children as the beneficiary of the trust?
Absolutely. So, and that's of any type of trust, whether that's revocable or irrevocable. Your children can be named beneficiary. If your children are minors, the great thing about that is you can also say when you want them to get the money. Or if you don't, if you know you have even adult children and they're not very responsible, you cannot allow them to manage their own money. You can name somebody else to manage the money for them. Um, but yeah, children absolutely are typically the beneficiaries of trusts, and yeah, so that's a good question.
Okay. Let me ask this other one that is in the chat. Is there a plan to leave real property with a mortgage to our children and have the mortgage paid off?
There should be a plan for that. Yes. And a trust can accomplish that. So a lot of people think that if their property has a mortgage on it, it cannot be transferred to a trust. What you should know is there is a federal law. It's called the Garn-St. Germain Act. If we have any nerds out there who want to look it up, there is some provisions in there that protect your right to transfer your mortgage property into certain types of trusts, most of the trusts that we design, without the mortgage company being able to trigger a due on sale clause. So you can transfer your mortgage property into your trust typically with no problems at all.
Very true. Oh, okay. Um, can you walk me through exactly what happens in the first 72 hours after a parent's death? Um, oh, I'm missing part of this question. After a parent's death, when there is a plan versus when there isn't.
Yes, I think that in one thing, so sometimes people do call me immediately after someone's passing, and it's always great. We're always happy to help in any way that we can. And if there's property, we'll say, just make sure the property's secure. And um, however, we always say there's no emergency right now. Like, unless there's some special circumstances that make something an emergency, there's typically nothing that needs to happen in the first 72 hours. So we would say, if there are memorial wishes or any types of that type of a plan in place, we would say find the document, see if they have any memorial wishes, and instructions regarding like whether they want to be buried or cremated, where they want to be buried, who's going to make that happen, consult with those, but then just take the time to like grieve the loss of your parent, and you know uh we'll send a checklist, but there's nothing groundbreaking that really needs to happen in those first 72 hours.
Understood. Okay, I have a few questions. One was texted to me, which you're in
Okay.
here, Sasha. It says, are there additional costs to having a trust, for example, tax or tax prep fee?
um so this conversation I'm going to base primarily on, say, middle class people who are not ultra high net worth, because a lot of people come to me concerned about estate taxes. And in New York, the estate tax exemption is over 7 million, and the federal is 15 million per person. If you're married, it's like 30 million. So most people don't have to worry about estate taxes. So the types of trusts that we set up for those high net
Oh,
worth people,
good.
yes, you might have to worry about transfer taxes. For most of the trusts we set up, the revocable trusts and the Medicaid type of trusts, there are no, when you're transferring your property into it, there's no transfer. We don't do anything that triggers transfer taxes for property or anything like that. So that is also why it should be carefully drafted. And if you do have property in some states like Pennsylvania, if you own like a house in Pennsylvania, they are very tricky with their transfer taxes. So if your attorney doesn't know what they're doing, then they could very well trigger transfer taxes if you own properties in other states. So you got to be careful.
Very true. And how often should estate plans be updated?
Good question. What we find as an industry standard, sort of statistically, is that usually some big milestone will happen in someone's lifetime, usually every 3 to 5 years, that would trigger some sort of change that might need to be made. So we always advise, reviewing it every 3 to 5 years. And we actually offer for our clients, we do complimentary reviews every 3 years. So you can give us a call and we'll take a look at a summary of your plan and just talk about your life. And you'll know, like, hey, this plan either still works for me or I need to make some updates. But generally every 3 to 5 years.
Yeah, or normally when like a big life thing happens, like I get married
Exactly.
or you have
Yep.
children or you get
Yeah.
divorced, you
Divorced.
need to make changes.
Yep.
Okay.
Yeah.
Um, Someone had asked, please repeat the name of the program again. Do you mean the law that she mentioned before?
Who was that?
Lauds, do you mean the
I'm
law?
not sure. If you're talking about the law, oh yeah, the law. Oh, so it's called the Garn Saint Germain Act. And that's again, it's a longer and it includes more, but there is a provision in there that allows you to transfer your mortgage property into a revocable trust and many types of irrevocable trusts. That does not apply if you have a reverse mortgage on your property, though. Just so you know.
Who interprets the trust if there's a dispute, the trustee or the court?
Well, it depends on what the trust says and how it's written. And usually, so we try to avoid court with our trusts as much as possible because anytime anything goes to court, the bills are racking up. Um, so what we typically do is we put provisions in for a trust protector to be appointed who can interpret and have whoever the trustee is to provide certain documentation and financial statements and things like that. But typically we try to avoid court. Usually the trustee is given quite a bit of authority in interpreting, but again, if there's some reason you wouldn't want to give your trustee that much power, that's why it's good to have these conversations with an attorney so we can draft it the right way. Sorry, I'm
Anybody
still
else
getting over
have
this cough.
any, anybody else have a question? Okay, we've got like 3 minutes left in here. You guys have asked some wonderful questions. I do have, let me see, I have a few more here.
I can't believe it's
Um,
been a half an hour. I feel like we barely scratched the
I
surface.
know that's why I said we're gonna have a part two. We have to, because this is just one of those. Can an LLC hold a trust?
Yes. I think it depends on what the goals are. Typically, what we see more often is a trust holding an LLC. So, if you have an LLC that you want to avoid probate with and you're doing some business succession planning, we might assign an LLC into a trust.
Trust accounts for our children, minor children included.
Um,
I'm not
yeah, I
sure.
mean, yeah, I'm
Okay.
not sure.
Do you want to
But
clarify your question?
So with estate planning and funding the trust, how do we establish like a trust account where the children can access the funds
during your lifetime or after if you pass?
after the passing?
Yeah, so the way that happens is again, it depends on the terms of the trust, but typically what happens after you pass, the trust will get a tax ID number. That tax ID number will be then used to open up bank accounts for, and your successor trustee, you'll name somebody to be the trustee if something happens to you. So whoever you name next in line will be the one responsible for making that happen, and they'll open up bank accounts. If you have multiple children, there might be a separate trust for each of them established, and they'll open the bank accounts that way.
I have a
Does
question. So the price that you quoted,
Mhm.
does that include everything? I think you said it. It includes the trust, it includes the will, it includes, what if you need a living will, like,
Yes, that's a
I
good
mean,
question.
what's
So
included in that price? I mean, that's a lot
yeah,
of money.
it's everything. It includes
Everything.
so a living will is kind of confusing because sometimes people come to me asking about a living will thinking it's an actual will, like saying who gets what. A living will is actually your medical directives.
Right.
So, just for anybody who wasn't aware of that, it does include that. We include
It's
healthcare
separate.
directives
Yeah.
within a healthcare proxy. So, since COVID, that's kind of the standard of practice. What we do now is we put that in the healthcare proxy itself, so it's all contained within the same document.
Okay. All right.
But yes, it does include that.
Okay. Good.
All right, guys, we've actually come to an end. I have
Woo!
one more question for Crystal because this is the question I ask everybody before they leave. And I have just put in the chat a link for Crystal for a free consultation because I know so many of you have so many other questions. You can do a free consultation with her and just reference Talk 30 so she knows where you
Yes.
came from.
If you reference Talk 30, I'll make sure I'm the one doing the consultation. So just put that how when it asks how you heard about us, write it in there and I'll make sure I'm the one who
Where
does
is
that
it? I'm
consult.
looking for it in the chat.
I'll put it again. Hang on. It comes up, it says Juga Law, get
Yes,
started.
yeah, I
All
see it
right. So
now.
this is my question for you, Crystal.
Yeah.
So let me pull it up. It's the last
We're
one,
not worried about
guys.
that right now. Please.
Um,
Oh, I'm sorry. I'm not muted. I'm sorry.
It's okay.
so if estate planning were a love language, which one would it be? If it was a love language, which one would it be?
Yes. And full transparency, Cindy Lee sent me this question ahead of time, and I was like, oh my gosh, I almost lost it because my husband and I are always arguing about love languages, and his is affection and words of affirmation, and mine is definitely acts of service. And so when I got this question, a huge light bulb went off because I was like, no wonder I love estate planning so much because estate planning is like the biggest and best act of service that you can do. So not only do I have like such a personal connection to estate planning, but again, I think that it's the best act of service that you can do for your loved ones, preventing them from being in a mess. At really the worst time of their lives when if something tragic happens. And so I would say it's definitely an act of service.
Yeah, it's the best way to show your love, right? It's your love in
Yeah.
action. Michael here says acts of service as well. Anybody else have another thought? For estate planning, I think so too. I agree. Well, guys, thank you. It's 7:03. I thank you for spending 30 minutes with us. I hope that you got tremendous value out of this. I did. We always learn when we come here. And of course, Crystal will be back because there's just so much encompassed in estate planning. So definitely reach out to her with the link. I will put it here again. This was
And thanks
recorded,
everyone.
so we will send out the recording so that you can have it and share it with others so that next time they'll be here as well. All right,
All right.
this is the end
Thank
of
Thanks
you.
Talk 30 to
everyone.
Thank you
me.
so much.
Bye.
Thank you.
Bye.
Thanks, Cindy
Thanks for
Lee.
joining us. Thank you,
Bye,
Crystal.
everyone. Thank you.
Bye.
Thank you. Have a good night.
Bye.